This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Yes.
Yes, sir.
Since
Yesterday it fell from the court that the division bench judgment should be looked at as the Bible for the court. With regard to the judgment only, I will make one just additional submission. Everything else I have submitted more or less yesterday. The judgment passed by the division bench with regard to upper primary selection, it had given a specific direction upon the commission to, since there are more vacancies than candidates, you are to
14,000.
Yes, 14,052. You are to call all of them for, you are to recommend them all. Recommend them all means I have to call them for counseling and send them to a particular school which they will choose. Now, yesterday I had submitted that the division bench did not tell me to bend the rules or to not to follow the rules. So after publication of the panel, we started the counseling process in compliance with the division bench's order, and as per the rules we have proceeded and absentee candidates have been excluded. It is specifically mentioned in the rule that the absentee candidates should not be allowed. This I had also more or less said yesterday. What I am adding today is that as far as the division bench's judgment is concerned, we have already complied with the direction because each candidate was called for counseling. They did not come. So once I have complied with the order once, the commission, according to my submission would be, should not be directed to repeatedly going on to comply for a second time, a third time, or a fourth time. Compliance has been done. Had I not called them for counseling, then what has fallen from the court was absolutely correct.
I'm not on compliance or non-compliance. You have complied, you have complied, you have not complied. It will be seen by the division bench. You have complied.
Yes. So since what the compliance division bench contempt, that is a different limb.
Sir, that is
today what I'm trying to say is that once I have complied, I have called them, all of them, for counseling. I should not be directed to again entertain them.
You have not carried out any appeal from the coordinate bench as well.
Yes, the coordinate bench, what I have submitted on the last day, yesterday, that is that the point that the absentee candidate will not be allowed is a statutory bar. That point was not urged before the coordinate bench. It was simply pointed out that they have come at a belated stage. This will make the process topsy-turvy.
Can I not take it that once the rule is there, it's deemed to have been considered?
Considered?
If you have not urged it, let's say, if you have not urged it, can I not take it that knowingly you have waived your right to that extent, not to urge?
My lord, if a counsel while making argument, he misses a point or has a statutory point cannot be waived actually.
Absolutely, but you should have then taken steps. You have not taken steps.
No, that is because it was an interim order. We are going to argue it on merit.
The moment, by virtue of an interim order, you allow one person to come and join in the counseling, forthcoming counseling. Then why you will not allow others to join the forthcoming counseling?
That I cannot do. The practical reason will be this. The difference between then and now. Then I had excess vacancies. I had called the candidates. The court passed interim orders.
Here I cannot understand.
Here what will happen? The 8th phase counseling will get cancelled.
No.
If I accommodate them, if the court directs me by way of an interim order to accommodate them later on, in a subsequent phase, because my panel is alive till 25th September. If the court says that very well, they have come before court.
Next phase of counseling.
Next phase, I can take them. I will not object. We will carry on with our 8th phase, and by the order passed by my lord, in the next phase, they will all be given the first priority for counseling in the next phase. Subject to checking of their documents, etc.
Of course.
But if they are to be included in this round, then my learned friend has 20 clients. There are 3 more matters before the court. Today, a bunch has been mentioned.
Maybe 100.
Yes. So I have only 48 vacancies. I have called the exact number of candidates. Everything is system generated. Even if I have the vacancies, if I am directed to include them on the first, I cannot feed it into the system so fast.
So how many more counseling will be there?
The number of counselings I cannot say. But our panel is alive till 25th September. As long as the panel is alive, as long as there are candidates.
Yes, I have understood. You tell me, just for this is for my understanding. Suppose the division bench has earmarked your periphery.
Yes.
14,000. That's the periphery earmarked.
Yes.
Unless it is diluted or changed, the periphery remains earmarked for 14,000. Now these 14,000, first you have to check when you will be allowing these, if I direct them to be allowed to participate in the council, this or the next. Then you have to first check whether these candidates come within these 14,000 or not.
That possibly there is no dispute.
I'm just.
I will check. I'm telling you.
Yes. Clear my mind.
Yes.
So let's say you have checked. You say yes, he is in 14,000. So this 14,000 earmarked, 14,000, and the vacancy is 14,000.
14,000.
Right? So 14,000 vis-a-vis 14,000. Where is the difficulty? I'm asking. Where is the difficulty to allow these all 14,000? Maybe in a phase manner. In a phase manner. That's your discussion. How many counseling you will hold? 100 or 200. That's your discussion. But this 14,000, why should not be allowed to be in the participate in the counseling? And then you assess them on the basis of in accordance with law. That is always the
there's no assessments left to be done. We will just check their credentials and call them for counseling.
So because of the situation,
the vacancy problem which just fell from the court.
Problem, that
is what the Honorable Division Bench considered that particular issue en bloc. Total all candidates 14,000. Kindly try to understand.
Yes, that's why I'm trying to clear my mind. Today the situation is crystallized. 14,000 vacancy, 14,000 candidates are there for counseling. So vacancy 14,000, candidates 14,000. Right? If that be so, let's say up till now you have held 20 counseling. Correct? So let's say 4,000 posts are filled up. Let's say you have gone for 5,000, 1,000 did not turn up, 4,000 has been filled. Right? So this balance 1,000 remains. Candidate remains 10,000. 10,000. So post remains 1,000 more. Naturally, 14 versus 14. Out of this left-hand 14 vacancy, you have given appointment, let's say, for 4,000. But you went for 5,000. 1,000 did not come or whatever, 4,000. Correct? So 1,000 is already remain vacant on that score, plus 13,000. Sorry, plus 10,000.
10,000.
So 10 plus 1, 11 is in your hand. And candidates are now 10. Out because 4,000 are qualified. So where is the difficulty?
Yes, that is.
You hold the counseling. You hold the counseling, of course, in accordance with law. And I'm thinking to put one more restriction. That suppose the petitioner shall participate in the next counseling. Right? He has to be judged on the basis of the counseling in which he has participated. Suppose he ranks 10th, but he did not participate. So naturally, the first choice has been filled up. Maybe in counseling, there is no place in X school. X may be his choice. That I am holding the rank of 10. Why should I not be given X school? But X school by that time has been filled up.
Yes.
So he will not get the X school. As on that
the available vacancy, that is understood.
That he cannot pick up that particular
That's right.
I am so score or higher. I will be taking a Baligoj government school.
So as on the date of available vacancy,
Absolutely.
On that counseling.
Absolutely.
On that counseling.
Yes.
Right.
Now, may I just
Here now tell.
respond to the first part? That is what the division bench has directed, 14,000. 14,000 en bloc entire vacancies were taken into consideration. What the division bench has not dealt with is the fact that there are more than 300 different categories. So I have 14,000 vacancies, but when I put the candidates into the category-wise school, then the candidates do not match sometimes. For example, as on date, I might have 10 vacancies in a general girls' school.
Absolutely can happen. I admit.
And that has given rise to the problem. The court did not take into consideration.
That is neither here nor there.
That is definitely here because we have filed. Firstly, kindly hear me. What is happening in the division bench, kindly let me submit. One candidate was not called for counseling, so he filed a contempt petition. We came up in the contempt petition and we have responded to the contempt petition as the direction is impossible to be complied with. If it is impossible, I cannot carry it out. Side by side, we have filed one CAN application for a direction from the court, submitting that for the purpose of compliance, even in a contempt application, the court may pass further directions. So we have asked the court to give us a direction so that we can get the matching vacancy from the government. We have approached the government. The government has said without a direction, we cannot do it because the rule does not support subsequently providing. It should have been argued before the court initially that the category-wise vacancy will give a rise to this difficulty. So we have also filed a review application before the court that the vacancy is equal to the panel. But the merit list has a 40% waiting list, which is in excess of the vacancies. So though numerically, when the court added all the vacancies, put them together, the court found I had excess vacancies. But the court did not visualize, or we were unable to argue. This point was not actually urged. So we did not argue that though there are 14,000, in certain categories, there will be excess. As on today, I have 3,500 extra vacancies because of the reason which the court just pointed out. But there will be no matching candidate. It might be a girls' school where I cannot send a male. It might be a scheduled tribe vacancy where I cannot send a scheduled caste. So putting it in this fashion, now they have, so that is why the review. So the matter is now before the division bench, the final decision. The court might accept my argument because it is backed by the rule that the panel, or rather the merit list is 1:1.4 of the vacancies. For every 100 vacancies, 140 candidates are there. And now that has created the problem. I might have a vacancy in Arabic, but I do not have a teacher. The scheduled tribe, there might not even be a candidate in the scheduled tribe category for Arabic subject. So that vacancy will remain vacant forever. That is why we are before the division bench. So what I was submitting is, even if the court is minded to direct us to hold the counseling, though I am saying that we have complied with the division bench's order by calling them for counseling. So now they cannot be absent and come on later relying on the division bench judgment.
Dr. Patro, I am not on compliance or non-compliance of the division bench. Absolutely, that's not my domain. From paragraph 39 to, let's say, 42 or 43, whatever, of the division bench, it's Bible to me. I will say, I will pass my order in the light of that.
Is it my submission to that is that we have already carried out this. We called them for counseling. They did not come. How can they get a second chance?
I will record your submission.
The division bench will not give them a second chance.
All right. That you test my order also, because one coordinate bench is there. So you have, if you have to test, you have to test galore. Go and test it. I don't mind. But I will follow this direction, and then my understanding of
testing is always my second option. My first option is to get an order from the court which will be suitable for all of us, not necessarily in my favor. That is why I submitted.
Dr. Patro, you are arguing very fairly.
That is why I am submitting. That is why I am submitting that even if the court allows an interim order to allow them to participate, kindly do not direct us to include them in the 8th phase of counseling, or it will get cancelled.
That I will consider. I will consider.
We will
That I will
accommodate
consider.
them in any subsequent phase.
Yes. That I will.
That order, if it is passed today, it will still be
That I
binding
will.
on me in the next phase.
Yes, absolutely. Absolutely. Yes, Mr. Bari. Just to this respect.
Anything more is to be submitted yesterday?
No, nothing. Only to that respect, that next counseling, not on this.
Question is, my lord, this counseling is going on and there cannot be any assurance the next counseling will be held. What prompted them to hold the counseling? Well, within 24 hours and 48 hours. And what is
Mr. Bari, then
what is the
the question of balancing equity will come. Why your clients chose not to?
that your lordships I submitted yesterday. That is my first name of submissions. The absentee. If your lordships kindly have a look to the rule, man, I'm grateful. When the court passes an order, it is deemed to have been taken into considerations.
I am not on that. Then I would not have minded to direct you to appear.
Yes.
If I take the rule 8 on the face value, then I would not have directed. But the practical problem will have to be seen. They will be granted, they will be called upon from the next 9th and onward.
Let it fix up the date. They will be called on such and such counseling. No problem.
I will direct.
Yes,
I will direct.
No. Next
There's a
counseling.
specific direction of court.
Next counseling, Dr. Patro cannot submit today that we are going to hold the next counseling.
Yes. Whenever.
No, whenever means before the expiry of the panel.
Yes, definitely.
Of course.
Yes. If they,
Mr. Bari.
what's the problem?
If there is a direction,
the query of the court, I met up yesterday.
No, you met up. But equally, what is troubling me equally,
Yes.
that you have chosen not to participate.
No, my lord, that has been your lordships. Kindly, again, I am repeating my own submission. Your lordships, don't take it otherwise.
No.
Your lordships, kindly have a look to this. My lord,
even if there is no further
Unnecessary
counseling,
complications.
if there is no further counseling, if the direction is there, I am bound to arrange it. I cannot escape.
my lord, this starts from base 3, Dr. Patro. Dr. Patro, learned advocate representing the commissioner, has opposed the prayer of the petitioner to allow her to participate in the ensuing counseling process in connection with the first state level selection test 2016. Since the petitioner, in spite of being permitted to participate in the previous round counseling, did not turn up. This was the submissions. Rule 8 was considered, deemed to have been considered because he did not turn up. That's why my lord, the hearing. Now, court, it is also submitted at this stage. If the petitioner is permitted to participate in the counseling, if she comes within the zone of considerations, that would make the entire process topsy-turvy. Exactly, the submission is being made. It is submitted that the stand has been taken on behalf of the commission that absentee candidates are not to be permitted in participation.
Absolutely.
That is because of the delay I have said it.
Which is scheduled to be held on 11th June 2025. Another limb of submission made on behalf of the commission. If the petitioner is permitted to participate in the counseling, ensuing counseling, a candidate has already been chosen for counseling should be ousted. First, before the considering the issue raised in the petition, this court needs to find out whether the petitioner is untendered candidates, but absolutely in my...
No, and that is upon them.
Yes. This court needs to consider the issue in view of the special facts and circumstances, whether petitioner has lost job since the entire selection first SLST 2016 for class 9 and 10, 11 and 12 has been set aside by the Honorable Supreme Court by judgment dated 3rd April 2000. It needs to be taken into consideration that petitioner also participated. Exactly, my lord, whatever submission is being made in our case also, participated first 2000 for upper primary level classes, where she was selected, but she did not participate in the previous round of counseling. Since at the material point of time, petitioner was working as assistant teacher in higher secondary schools on being selected in the selection process, first level selection test 2016, 11 and 12. Subsequently, petitioner has lost job after such selection process has been declared illegal, which triggered the present petition, and a prayer is made to permit her to participate in the ensuing counseling process, which is scheduled to be held 11 June. In view of the aforesaid scenario, concerned authority of the West Bengal Central School is directed to permit the petitioner to participate in the counseling scheduled to be held if the petitioner comes within the zone of consideration in terms of her merit position in the first, and if the petitioner is not entered candidates. The court was cautious. If the exactly observation of this,
Very well.
whether my lord, if the petitioner comes within the zone of consideration.
As a single petitioner, fair enough.
No, my lord, not a single. Not a single
Sir,
petition.
now I will pass my order. I will pass my order. Ask.
But, may I have your lordship's kind leave, my lord?
And division bench judgment need not be cited again and again.
It is my Bible.
Yes.
It is my Bible.
Yes.
And it is because of the division bench I am passing this order. Had the division bench not been there, I would have thought twice.
Very well.
Only one more thing, there should be a limit to how long we should entertain first phase counseling candidates. If I have 3 more rounds of counseling, they will still be coming. They came for 5th,
Question
they came
is
for 6th.
14,000. Question is 14,000.
That I have replied.
In the peculiar facts circumstances, question is 14,000.
Yes, as per 14,000 they were called.
You don't go for 14,001. I mean, whatever the number plus 1.
14,052.
Whatever. You don't go plus 1. But here is 14,000 candidates. Here is 14,000 vacancies.
Very well.
You have to give them opportunity. You have to, in view of this situation.
Yes, that we are trying. We are trying to do it. It's not that.
That you have to. Acha, you admit the facts as reflected in the order of Justice Bhattacharya?
Yes, yes.
Facts.
Yes.
The single bench, 9th June.
Yes.
The order 9th June
Yes.
passed by Justice Bhattacharya allowing one candidate to participate.
Yes, yes.
Facts you admit.
Yes.
Right?
Only distinguishing point is that was 7th phase counseling. They could have.
That's your submission.
Yes, yes.
But facts are admitted.
Yes, yes.
The situation of the petitioner.
Yes, top loser and
those facts are admitted.
First phase counseling.
All right. Now you listen. The principal writ petition. আচ্ছা না তার আগে বড় হবে, হ্যাঁ, আস্তে আস্তে লিখতে হবে। The petitioners participated in 2 selection processes, namely, first state level selection process, SCAP, LCAP, SCAP, TCAP, first 1 ST. এটা পুরো bold, 2016. For classes bold Roman 11 and Roman 12. Enter চিহ্ন ব্র্যাকেটে for short the first selection process and also first state level selection test ওটা process না test হবে দিদি first level selection test 2016 and also second এটা and also bold হবে first state level selection test যেমন লিখেছেন 2016 ব্র্যাকেটে upper primary ব্র্যাকেটে for short the second selection test for being appointed as assistant teachers in upper primary level classes. the paragraph. The petitioners, please listen.
Yes.
Please listen. The petitioners were selected in both the said selection processes, comma, as referred to above, and became eligible to participate in the counseling process. Paragraph. Petitioners opted to be appointed as assistant teachers in higher secondary section.
Earlier selection process. Yes.
Of a government aided recognized school. I'm just quoting from 9th of June. Government aided recognized school. Since according to the petitioners, Didi, total hobe, hai, all court fees paid. Ask your junior.
I know personally I have checked.
According to the petitioner, schooler por comma, petitioner por comma, it was a better opportunity for them to work as an assistant teacher in higher secondary section rather than to be an assistant teacher at the upper primary level. Paragraph.
No, my introduction.
Huh?
These candidates, 20 candidates, some of them are 9-10 teachers, some of them are 11-12 teachers. They have clubbed themselves into a single rate, but they're from different. That is what I just checked.
Two selection process, one 9, 10, 11, 12, another upper primary.
No.
No,
9, 10, 11, 12. Two different selection processes, both got cancelled.
So তাহলে এই প্যারাগ্রাফটা কি হবে? Petitioner opted to be appointed as an assistant teacher. আপনি দেখবেন না, আপনি ছাড়ুন. In higher secondary section. 9 June, come to second page, second paragraph.
Page.
9 June, second page.
Second page.
Second paragraph. The petitioner opted.
Higher secondary section of the government aided recognized system. Your lordship kindly secondary higher secondary. Stroke secondary higher secondary.
Petitioner কি লিখেছেন পড়ুন. In secondary stroke higher secondary, in both secondary and higher secondary section of a government পড়ুন আর সিন্স থেকে বাদ দিয়ে দিন দরকার নেই হলো প্যারাগ্রাফ করুন. The selection process for classes Roman 1, Roman 11 and Roman 12 has been set aside by the Honorable Supreme Court by its judgment dated April 3, 2025, comma, in the matter of State of West Bengal versus Boishakhi Bhattacharya, bracketed Chatterjee and others. পড়ুন এই জায়গাটা. কোনো তাড়া নেই, আস্তে আস্তে, খুব ইম্পর্টেন্ট ম্যাটার. সুপ্রিম কোর্ট যত সময় লাগে লাগবে. Inter alia in the matter of inter alia আগে পরে comma in the matter of along with other matters. along with other special leave petitions. Poster. Subsequently, these petitioners have filed the instant writ petition with the following prayers. Quote 1. Quote 1. Set out prayer A to G from page 16 of the writ petition. Hello. ঠিক আছে। The instant writ petition was taken up for consideration by the coordinate bench on May 14, 2025. When the coordinate bench directed the Central Schools Council, West Bengal Central School Service Commission, bracketed for short the commission, to file its report first. The said order further reveals that it was submitted on behalf of the petitioners, that they have submitted their representations before the council commission to avail of an opportunity of counseling. The supplementary affidavit paragraph discloses a notification dated July 24, 2025, issued by the commission, whereunder, pursuant to the order, judgment and order of the Honorable Division Bench, dated order of Division Bench in MAT 633 of 2021. The council has called for the 8th phase of counseling, scheduled to be held on July 29. Where is that?
Notification says no.
Where?
Supplementary affidavit notification.
Last time. 1st August.
Where? Where the notification says?
One of the notification supplementary affidavit. Page
Yes,
5.
yes, read.
Page 5, bottom portions. Counseling date 1/8/2025. The Lordship got it? Page 5. Supplementary affidavit, page 5.
Full stop. কি বললাম?
The commission, wherein that pursuant to the judgment and
633 na 638.
38
Council, the commission has.
Called for the 8th phase of counseling civil
Bold. August 1, 2025. Post. The petitioners pray for participation in the said 8th phase counseling. Post. Paragraph. In view of the above, the writ petition was mentioned before this court and was taken up for consideration first on July 29, 2025, and then today. Paragraph. Referring to a direction of the coordinate bench dated paragraph, June 9, 2025, in the matter of Mukti Bishwas versus the state of West Bengal and others, rendered in WPA 9980 of 2025, the petitioners pray for the interim order to participate in the 8th phase counseling. Paragraph. Since the notification of the commission dated July 24, 2025 has been issued pursuant to the direction of the Honorable Division Bench in MAT 638 of 2021, at the outset, the relevant portions from the said Division Bench judgment dated August 28, 2024 are quoted below. Quote 2 from para 39 to 39, PO2. Quote 2. না এর আগে ঠিক এটা যেমন থাকবে তার আগে একটা সাবমিশন করুন। ডক্টর সুতনু কুমার পাত্র, learned counsel appearing for the commission, submits, এটা পুরো ঢুকবে তারপরে তো ওইটা হবে। ডক্টর পাত্র submits that these petitioners were called upon for counseling, were called upon in the first phase of counseling, but the petitioners failed and neglected to attend the said first phase of counseling, and even thereafter till the 7th phase of counseling, the petitioner have never prayed for participation in the counseling process. First up, it is only at the stage of 8th phase of counseling the petitioners pray for participation in the counseling process. Paragraph. Relying upon Rule 8,
Schedule 5, Clause 8. Not Rule 8. Very last page. Very last page of the
Relying upon bold clause 8 to schedule 5, schedule Roman 5.
yes,
Sure.
yes.
Schedule Roman 5 of the West Bengal, W cap, B cap, school service, S cap, S cap, commission, C cap, first bracket শুরু হচ্ছে, selection, S, আপনি দেখে নিন তো। বোল্ড করে। Bracket for short, the said 2016 rules. কি বললাম পড়ুন। Rules, চলুন rules, comma. Dr. Patro submits that an absentee candidate shall not be called for any second counseling. Therefore, the relevant statute imposes a bar on the petitioners not to participate in any other counseling when they were absent in the first phase of counseling. Paragraph. Dr. Patro then submits that these counseling, including the forthcoming 8th one, are being held pursuant to the direction of the Honorable Division Bench, dated August 28, 2024. And the Commission has been trying to accommodate the eligible candidates in terms of the said judgment of the Honorable Division Bench. Strictly in terms of the said Honorable Division Bench. He further submits that the Commission has been facing some technical difficulties as well as legal difficulties while holding these counseling processes. And accordingly, the Commission has already applied for review of the Division Bench judgment, which is pending before the Honorable Division Bench. Review number?
Yes, 137 of 2025.
The review has been registered as RVW
137 of 2025.
Paragraph. In addition to the above, the Commission has been facing contempt despite their effort in compliance of the direction of the Honorable Division Bench. The Commission has been defending those contempt proceedings before the Honorable Division Bench. Those contempt proceedings before the Honorable Division Bench. Paragraph. On query being raised, paragraph, on query being raised by this court, Dr. Patro, learned counsel appearing for the counsel, has informed that
Commission, for the commission.
আমাদের ছোটবেলায় council ছিল তো, the commission has informed this court that no appeal has been carried out by the commission from the order dated June 8, 2025. From the order dated June 9, 2025 in the matter of Mukti Bishwas Supra, passed by the coordinate bench. Poster. In his usual fairness, he also submits that the factual position in respect of the situation of these petitioners in this writ petition are similar with the writ petitioner in the matter of Mukti Bishwas Supra. He has opposed, Dr. Patro has opposed the prayer for interim order. Firstly, on the ground that if these petitioners are allowed to participate in the forthcoming eighth
phase counseling.
Eighth phase counseling, the same shall be in clear violation of the statutory rules under the said rule of 2016, as referred to above. এটা firstly holo, firstly এটা bold, comma. Secondly, these petitioners were deliberately absent in the first phase of counseling, which was their due turn. Comma. Now, if these petitioners are directed to participate in the forthcoming eighth phase of counseling, then there will be a huge cascading effect as for the purpose of eighth phase of counseling, a earmarked number of vacancy has been located. After calculating the proportion of the candidates already called upon for the eighth phase of counseling. The entire chain of events will be upset, will be disturbed. Full stop. What else?
Only where my lord has dealt with the division bench, I have submitted that since they were called for the first phase counseling, as far as the petitioners are concerned, that part has been complied with. So they do not get a second chance.
Thirdly, he submits.
That part has been carried out.
Thirdly, Dr. Patro submits. Once the petitioners were called upon for first phase of counseling, in compliance of the direction of the Honorable Division Bench, the obligation of the Commission is over insofar as these petitioners are concerned. And these petitioners cannot be called upon for any further counseling process.
What I require to be recorded is that we have carried out that part of the division bench's order.
The commission has already carried out the direction of the division bench.
As far as the petitioners are concerned.
And that's right.
My lord.
Full stop. What else?
My lord, more or less everything is covered.
These are the
They
things.
missed several phases of counseling also that my lord has dealt with.
Yes. Otherwise, how 8th will come?
Yes. No, my lord has mentioned it. That is it. More or less, that is my submission.
And what about the next phase of counseling, your submission?
Yes. My lord has just dictated that it will have a cascading effect and will disturb the 8th phase.
No. 9th, 10th, 11th. The next phase is when?
Yes. The phases, the dates are not fixed. My panel is alive till the...
Yes. Upon further query being raised by this court with regard to the life of the panel, Dr. Patro submits that the panel is alive till
25th September.
Hold, Didi. September 25, 2025. Duti 25 kintu. September 25, 2025. Full stop. He submits that so long this panel shall remain alive, the counseling process shall have to be continued in view of the direction of the Honorable Division Bench. And the commission shall continue with the counseling process accordingly. These are
Yes.
paragraph.
One submission I had made that if the court allows by way of an interim order, then in a subsequent phase, that...
Full stop. Dr. Patro, paragraph, further submits that even if this court thinks it fit to give a chance to the petitioners for participating in the counseling process, then the same shall not be granted in the forthcoming 8th phase of counseling. Yes. Right?
Yes, in the 8th, they cannot be accommodated.
That's right. I've said that.
If the court directs, then since the panel is
there, always there. Full stop. Really good. After considering the rival contention of the parties, and upon after considering the rival contentions of the parties, and upon perusal of the materials on record, at the outset, chepe din hota. At the outset, কেটে দিন, যা লিখেছেন কেটে দিন, লিখুন নতুন করে। মনে আছে তো কতটা কাটতে হবে? সব কেটে দেবেন না, লিখুন। At the outset, it appears to this court from the said notice dated July 24, 2025, that the 8th phase counseling is going to be held in terms of the direction of the Honorable Division Bench in the matter of Devashish Mudi, MUDI and others versus State of West Bengal and others. Inter alia in the matter of.
The first matter is Rajiv Brahma. Kindly.
Oh, Rajiv Bharma. Devashish Mudi kede din, likun Rajiv Bharma, Brahma, BRAHMA and others versus State of West Bengal and others. Ki bollam? It appears to this court that from the said notice dated such and such. Brahmo and others versus State of West Bengal and others. Comma, MAT 6638 of 2021. First of all. Accordingly, the relevant portions from the said judgment are quoted below. এবার এই কোট 2টা লিখে দিন, কোট 2, page 30, para 39 to 44, page 46 থেকে কোট 2. First of all, first of all, on the respectful reading of the judgment, which is binding before this court, it further appears to this court that the commission has been directed to prepare and publish the merit list and the panel following the relevant rules of the bold 14,052 candidates, 14,052 candidates. Within a specified time mentioned there. Also, thereafter, the commission was further directed to hold counseling and recommend all the said 14,052 candidates, who appeared in personality test, personality PCAP test, TCAP, dutoi cap bold, bracket PT. And upon recommendation, the appointment letters were directed to be issued to such candidates by the competent authority within the time frame mentioned there. Pardon. Therefore, it is the obligation and duty of the commission to hold counseling for the said 14,052 candidates in accordance with law, in strict compliance of the direction of the Honorable Division Bench. Pardon. These petitioners have already been qualified up to the personality test level, and then only they were called upon for the first counseling process. The fact remains, these petitioners did not attend and were absent in the first counseling process, which was the due counseling process for them. No explanation has been offered on behalf of the petitioner as to why they were absent in the first counseling process.
Explanation was offered. Explanation was offered.
Show me.
That, yes. That I have said the matter was pending before the Supreme Court, we could not participate.
No cogent explanations.
That can be.
No cogent and sufficient explanations in the eye of law, comma, according to this court, comma, was offered.
additional bid when absent first class within and sufficient in the eye of law, according to this code, was offered to the commissioners as to why they were absent in first counseling
process. First. The relevant rule from the said 2016 rules, which imposes a bar, according to Dr. Patro, to allow a candidate in the second counseling, to allow an absentee candidate in the second counseling, cannot be taken as a plea before this court at this stage, when the direction of the Honorable Division Bench is already there. First of all. Similarly, from the order dated June 9, 2025, passed by the coordinate bench in the matter of Mukti Vishwas, it appears that the Commission has raised the same point, same issue, that an absentee candidate is not to be allowed for the second counseling. But the order was passed by the coordinate bench, allowing the writ petitioner therein to take part.
But it was an interim order.
In the next counseling, in the forthcoming counseling. Full stop. It is true that this was an interim order. It is also true that this is an interim order. Full stop. But no appeal has been carried out by the Commission. Full stop. Petitioner has been called upon.
My lord, yes. In the 7th phase, that is over.
That petitioner had also been called upon in the 7th phase of counseling, held on
11th June.
June 11, 2025. Thus, the Commission had accepted the said interim order and acted thereupon. Paragraph. Considering the special and peculiar circumstances in connection relating to the self-same selection process, and in view of the direction of the Honorable Division Bench, in the matter of Rajiv Brahma Supra, this court is of the view that the second opportunity should be granted to the petitioners to participate in the counseling process. First paragraph. However, considering the submissions made on behalf of the Commission that if these petitioners are allowed to participate in the forthcoming 8th phase of phase counseling, for which the entire list and procedure has been completed, the same will have a cascading effect, and the entire counseling process will be disturbed with all its consequential series of events. However,
that if listeners are allowed to forthcoming counseling for which the entire list of procedures and procedures has been completed, the same as a cascading effect.
I go shoot, however,
Considering the submissions,
comma, and also considering the fact that despite opportunities, petitioners chose to remain absent in the first counseling process, which was the due counseling process from them. The equity is also necessarily required to be balanced. Between the two. Does the petitioners order shall be allowed to participate in the immediately next phase of counseling process after the forthcoming 8th counseling process. And the Commission is directed to permit the petitioners to participate in the said counseling process. If the petitioners come within the zone of consideration in terms of their respective merit positions in the list, and if the petitioners are not tainted candidates, tainted kothata bold, tainted candidates. The concerned authority of the Commission at the time of counseling, this Dr. Patro, you listen carefully, yes, because yes, these are all procedures.
My lord.
You are the best person who is aware of this procedurally. The concerned authority of the Commission at the time of holding counseling shall strictly verify the credentials of the petitioners along with all other relevant records and materials. Full stop. What else?
My lord, this is by way of an interim order, appearance.
Of course.
It has not been mentioned in the order.
I have said so. All right. Next, you first complete. What else? Procedurally, if anything is left.
By going by Mukti Biswas's order, it is mentioned that the participation of the petitioner in counseling shall abide by the result of the petition.
Full stop. Paragraph. It is made clear that the petitioners, please listen to this, I am adding one sentence. It is made clear that the petitioners shall take part in the counseling process on the basis of the available vacancies.
Yes.
As on the date of the very counseling process where the petitioners shall participate. When the petitioners shall participate. Paragraph. It is also made clear that this order shall not create any right or equity in favor of the petitioners if they are found not otherwise eligible according to their merit position in accordance with law. Right? Paragraph. The participation of the petitioners in the counseling process shall abide by the final result of this writ petition. Full stop. Paragraph. The respondents shall file their report in the form of affidavit.
But the report was directed to be filed.
Yes, the time may be extended.
Let their short direction for affidavit.
Very short.
Very short direction for affidavit. Let them deal with that.
Yes, we will contest. So without the affidavit, how can I?
That's right.
The direction was there, just extend it.
Time to file report on affidavit as already directed by the coordinate bench stands extended on the prayer of the commission, and the same shall be filed on or before
2 weeks.
Yeah, date.
By 13th?
Auspicious.
That is 2 weeks.
By 14th. August 14, 2020.
Obliged.
Paragraph. Affidavit. মাথায় আছে আমার এখনো। Paragraph. Exception in the form of affidavit shall be filed on or before
Within 1 week thereafter.
21st.
August 21, 2025. Paragraph. After completion of the aforesaid period, parties shall be at liberty to mention the writ petition before the regular bench, subject to its convenience and upon notice to each other.
One line is required to be added. Dr. Patru's recording that the 21st September, before 21st, the council will be held. Otherwise, if the council is not held, we will be remedialess. Because of
then the panel will not be exhausted.
No. Question of panel will expire after 21st. So counseling should be held before 21st.
25th.
25th, whatever it is.
That
so Lord
is necessary.
That line is
there is
required
not to hold a counseling. It has to be done.
That is required to be mentioned.
Yes.
সামনের দিকে আসুন। No, but one thing, Mr. Bari, it's pursuant to the direction of the division bench.
Yes, what's the harm if I allow, if your lordship we appear in day after tomorrow?
No.
When harm is
200% there because you chose not to appear.
No. That
had this division bench not been there, Mr. Bari, had this division bench not been there, I would have thought second
division
time.
bench help us.
That's
division bench say under the rule 12.5, 12.6,
right.
And we have covered the rule 12.5, 12.6.
Right.
There is no question of absentee candidates. And absentee candidate.
I'm not on that. Had this division bench not been there.
Yes. Division bench helpful for us.
Absolutely. That's why
That's why, my lord, if your lordship I'm extremely grateful your lordship is permitting us to appear in the council. Which is likely to be held before expiry of the panel.
That's what unsaid. There cannot be any after expiry. What is the apprehension?
আগে থেকে 2-4 প্যারাগ্রাফ আগে।
But the query being raised by this court with life of the panel of Dr. that the panel is alive is September 2025. It happens that soon of the panel shall remain alive. The process shall
Yes. What else?
Madam, the council.
Suppose process shall have to be continued. It is his submission.
Madam, counseling process is maybe exhausted on 7th itself, on 1st itself. Then I will
Sir, it is
immediately.
written that so long the panel is alive, I will not add. It is written so long the panel is alive, he submits. আবার পড়ুন সাহেবকে শুনিয়ে দিন. You listen carefully.
Upon further query being raised by this group, the life of the panel, Dr. Patru submits that the panel is alive till September 25, 2025.
Yes.
He submits that so long the panel shall remain alive, the counseling process shall have to be continued in view of the direction of the Honorable Division Bench.
John.
জিতে গেছেন আবার কি চলবে
আমাদের ডিউটি কোর্টের কাছে বল
Of course.
the court will pass an order.
Of course. And I enjoyed hearing all of you. I
Our
enjoyed
duty
it.
is to assist the
And on the basis of today also, you have seen, upon notice to you, few matters are mentioned.
Yes.
my submission was recorded in the yesterday's submission has been recorded earlier. Today, no submission on
Are full of your submissions are recorded.
yesterday's recording.
Whatever you have submitted today itself is
Today I have not submitted. Whatever submission.
everything is recorded, sir. You will find the interim order. Go and appear in the counseling process. It is recorded.